This 3-part series continues. If you're tuning back in, this episode is about deep diving into contractors and the gateway test, as well as the 30-day rule that came into collective and unionized environments. Stick around as I break down key concepts, take a look into what cases we've seen to date before finally looking at your listener questions that you sent through a couple of months ago. Let's keep the train moving, full steam ahead. Hi everyone, welcome back to Lawlands. I'm Sanam, and this is the Employment Law Done Right podcast, where I help businesses get their people decisions right. I'm here to give you the legal thinking without that legal bill. Okay, so we are back at it again. We are at part 2 now of the series, and like I said, there's a lot to unpack, so I thought we'll split it up into 3 episodes. Now we are looking at the contractor test that has been introduced. This is fully in force. The old test that we used to have, as many of you know, looked at the real nature of the relationship, so the true nature of the relationship, regardless of what the contract said. And that is what I have spoken about before as well. I've done episodes on it. In the old test, courts would consider how much control you had over the contractor, how well they were integrated in the business, what the intention was at the time of engaging them and signing the agreement, and what promises were made. And it often looked past the labels that you would give a person, which would be a contractor. And it created real unpredictability for a business. So let's be honest, you never knew if you got into this contractor arrangement, if it could go south or where it could go, and you had to keep lines very, very clear. It's hard to do that with a contractor. I remember a couple of years ago, I did a post about how contractors shouldn't be integrated into the business and they shouldn't be involved in the day-to-day or company meetings and even just hanging out with the staff. And somebody commented and said, well, I work as a contractor and it's actually quite isolating to never actually be part of a team. Usually people feel very much like that is what a contractor is. But from a contractor's perspective, some of them might want to be integrated. So look, this test has really shaken things up. And when we look at the Uber case, that was a perfect example of unpredictability that can come up, whether they're employees or not. And now the Parliament's response, or the coalition government's response, has been to introduce this gateway test. And effectively, all it's saying is that if you meet these 5 criteria, you have to meet all 5. If you do, then your worker is a specified contractor, and they cannot challenge the status of them being a contractor at the Employment Relations Authority or at the Employment Court. It sounds great, but the 5-part tests are only as good as how carefully you meet them. And we're going to get into exactly what is required. So let's have a look at the law and break it down. Basically, what's been introduced is a 5-part test. Like I said, it's criteria that must be met. Miss one, your test fails. Simple as that. But when your test fails, you may be wondering what's going to happen. Don't worry, it's not all doom and gloom. You will be back using the old real nature analysis. So looking at the actual relationship, how much control was had over the person, how much they were integrated, what the intention was. So let's start by looking at criteria 1. The first thing, simple, easy, I hope we can all do it, is that there needs to be a written contractor agreement or some sort of contract in place that states that the person is not an employee. It can state that they're an independent contractor, but it is important that that contract makes a distinction that they are not an employee. So if it says independent contractor, all the terms relate to an independent contractor, great. But the reason why the wording was changed slightly for this is to account for contracts that might use other language and other wording where it still specifies that the person's not an employee. The agreement itself must contain very clear statements about the person's status. What are they? What kind of worker are they? And it has to be very clear. Easiest thing to do here, independent contractor, just put the label on. This is the time when labels matter. Put that label on. Now, criteria 2, the arrangement does not restrict them from working for other people. The exception is that you can restrict them while they are actively performing work for you. But a blanket exclusivity clause is absolutely not okay, and the test will fail. Meaning that if you have anything in your contracts that say that the contractor can't actually work for other people, or that they are in a restraint of trade, or that there is restraints put on them for trade for the next 6 months, a year, that is not okay, and that will make your test fail. So make sure that you've ticked that off in terms of the criteria. The third one is that the contractor is not required to work set hours or on specified days for you. Or the other option is that they have the right to subcontract the work to someone else. It's one or the other in this case. If you require set availability, subcontracting rights must be genuine and documented. You should allow the contractor the right to subcontract the work to somebody else. And now the fourth criteria is that you cannot end the arrangement just because they declined a piece of work. So sometimes you might be in an arrangement with a contractor for a particular service. Let's say that they needed to build an app, for example, and that is the outcome. That's the service that they're providing. And then maybe once they're reaching delivery of the app and finishing off that specific service, you might realize that you need something else from them. And if they refuse one of the jobs and you turn around and go, well, in that case, we don't need you anymore, then that is not okay. If refusing one job costs them the entire contract, that is a control dynamic the test cannot survive. It is best for you to make sure that you are flexible and that if you pitch any ideas and the contractor says no, that you're just like, okay, we'll just keep moving on. No packing up, no ending the contract, just keep moving on. And then 5 is before signing, they have to have a reasonable opportunity to seek independent legal advice on the agreement, on that contract. Stock standard, we know across the board that that's what it is. So what does a reasonable opportunity mean? It doesn't mean that you have to pay to get their legal advice. I did hear a couple of questions here and there thrown around over the last few months. But yes, just to confirm, you don't need to pay for their legal advice. You just need to be able to show that they weren't rushed into signing. So usually the best thing to do is a covering letter to give them the contract and to say to them that they can go and seek independent advice and give them ample amount of time to go and get that advice, like 5 business days. If they choose to sign earlier, but you have provided them with that opportunity, then that is fine, but make sure that you keep it on their file. And that's it. So what happens, like I said, when the test fails? Remember I said that the real nature of the relationship test applies? The ERA or the employment court will look at control, integration, whether there was genuine independence. A failed gateway test doesn't automatically mean that they're an employee, but what you've lost there is that gateway statutory shield. So that thing, that first layer that protects you is gone. And now you're going to start looking at the actual real nature of the relationship. If we look at this from the cases that we've seen, one thing we've realized very quickly is that this law is not retrospective, meaning that it applies for all claims made from 21st of February onwards. For any claims that happened before that date, the old test applies. And that's why we keep seeing contractor cases time and time again going over the last few months, and it's all related to the old test because it's just not the date yet. We're waiting. If a contractor wants to argue they were an employee for the last 3 years, the gateway test applies if they raise their claim after the 21st of February. Pre-February claims are assessed under the old rules, and I'll leave it at that. One thing that has come up is, can I actually vet those subcontractors? So as long as it's reasonable, it's required for the services that are being provided, and you can kind of back yourself up with a genuine reason, criminal record checks, site inductions, and even statutory compliance requirements are all things that you can require. You don't lose control of who's on site just because the gateway test requires the subcontracting rights. So you get a bit of balance there, but again, that justification needs to exist. Let's say if you're a company let's say you're a law firm, perfect example. Let's say if you're a law firm and you're subcontracting some of the work out and the person is accessing your systems and things like that, you might want to make sure that you've done the required background checks and things to make sure that there is no issues coming up. That is where it would be very, very useful. My personal take on this is that I've seen a lot of commentary. A lot of people are saying that the gateway test gives you certainty. I believe that the gateway test will give you a level of certainty if you genuinely run an independent contracting arrangement, but it doesn't give you certainty if you just redraft the contract and carry on as you were doing. If your contractor arrangement walks like employment, quacks like employment, a new agreement with different wording will not save you here. So just keep that in mind. And one thing that I wanted to flag with you before we move on to looking at a specific case is we know that with the general election later this year, there could be a change happening in New Zealand and we could see this gateway test reversed. I think a lot of people out there are saying how bad it is and it's not a good decision and it shouldn't have been brought into place. But that doesn't mean you shouldn't clean up your arrangements now. You absolutely should, but build arrangements that would pass the old test too. So that is the best way you can do a bit of both. Now, there was one case that came out around a construction company, and it was a recent case that we actually saw in Stuff as well. Basically, what happened was a 1-ton slab had slipped and it had injured a contractor. The contractor spent 3 months in hospital and about a year recovering. He claimed that he was an employee of the company that engaged him, and he'd been unjustifiably dismissed and disadvantaged because obviously as this all happened, the arrangement ended. Now, the authorities' starting point is worth your attention. They basically said that the contractor could not be a specified contractor under the gateway test because there was no written agreement specifying their status. No written agreement, no gateway, full stop, right? Because we know that you have to meet all 5. What I would say here is that the gateway test is only a shield if you've built it. It is the criteria that you need to follow. And without it, you are in the old world of the real nature of the relationship under common law, arguing about how the relationship really operated. That's kind of the discussion that we've seen around the gateway test. And we'll see where it goes. Like I said, elections later on this year, so we'll see where that lands. And the last thing that I wanted to discuss is something I won't go into too much detail on because I think it is quite nuanced. It is for a unionized environment. It is about the 30-day rule being scrapped and out the door. It has happened many times over the years as we see government change. Previously, the law was that a non-union staff member had to be employed on collective agreement terms for the first 30 days if a collective applied to that specific workplace or industry. That requirement is removed. You can negotiate individual terms from day one. What stays though is you must still tell new employees a collective agreement exists, give them a copy, and provide the union's contact details. That's it. You don't need to put them on the collective agreement, but you do need to provide them that information and their individual employment agreement. The information obligation remains, but the terms obligation doesn't, and that's what has changed. Now, what can you do right now dealing with the situation? Audit every contractor agreement you've got, not just the recent ones, all of them. All of the ones where you might be ducking in and out and still engaging the person. And for each arrangement, run the 5 criteria. There's no harm in doing that. Be honest about whether it genuinely applies and passes, and pay particular attention to criteria 2, the working for others, and criteria 4, the declining work. These are the most commonly failed areas in practice. And right now, I would say the availability criteria is another thing that you need to have a look at, basically saying that, you need to be available between set times. Fix the written agreement. Don't just focus on the title and call it an independent contractor agreement. The agreement must contain a very clear statement about status and make sure that your clauses are compliant and you're not adding in restraints or anything in there. For anyone you're bringing on from now as a contractor, give them the time to seek advice, document that you did, your stock standard, covering letter that goes out. I remember when I worked in advisory, I used to get asked all the time, what happens? What happens if the person does tick over into that employment territory and they are seen as more of an employee? If we just move them across, will that remove our risk? Well, it doesn't remove your risk, it minimizes it to a certain extent, but the risk will always be there. But is it better to have the risk over a 3-year period or over a 3-month period? So I would say if you can see it, the writing's on the wall, the person looks more like an employee, and you are well and truly past the point of the 5 criteria test, and when you look at the real nature, it truly is an employee, then you probably will need to move them onto that employment agreement. Now, all of these things, the issues that can come up in the workplace, this is the bit I built the workshops around. Delving into employment law, but not getting bogged down in the legislation, the case law, and all of that, but actually taking the meanings that's needed. That is why I do what I do. And like I've mentioned, the website launched and the bespoke workshops are something that I am offering. I'm screaming it from the rooftops. So please take a look at it. The website is lawlens.co.nz. I'm really excited to start helping New Zealand businesses so that they can make decisions quickly, efficiently, and without fear of retaliation. We'll tie everything off by looking at the questions that came through. I'll kick it off with the first one, where somebody said that our contractor has worked exclusively for us for 2 years. Practically, they can't work for anyone else because we keep them fully busy. Does that mean they fail criteria 2? Well, no. And this is the important distinction. You have not barred them from working anywhere else. You've just kept them busy. The test looks at whether the contract restricts them from working for others, not whether they practically do or not. If your agreement does not prohibit them from working for other clients, other customers, criteria 2 is met. And that is that. Even if they've never actually taken on other work or provided other services, you're not restricting them. And in that particular scenario, the practical reality doesn't override the contractual position there. But you should still check the agreement agreements, because if there's an exclusivity clause buried in there, that is a problem regardless. Now, the next question I actually added into the mix. I need cleaning done on site every night between 6 p.m. and 10 p.m. The reason why I did this specific question is because, funnily enough, it comes up quite a lot. And what I've noticed is that technically, if you look at it, if you require them to work, they could fail the criteria, especially when we're looking at criteria 3. But the answer is they wouldn't automatically fail. But this is where you really have to be precise, because it's easy to trip yourself up. And criteria 3 is about whether the person must work set hours or days for you personally. And that distinction is the whole thing. Requiring the service to be delivered in a window is not the same as rostering an individual. If you need a building cleaned between 6 and 10 p.m., that's a service standard. And it's a feature of the service, it's a feature of the job, not control over the person. What you can't do, though, is require that one specific individual, your contractor, to be there every night as a person that clocks in at 6 and finishes up at 10. And remember, it's an either situation, right? It's one or the other. And if we go back to what I mentioned earlier, criteria 3, remember, gives you 2 routes. So you only need to pick one of them. Remember, route 1 was that you don't require them to work set hours or days personally. You set the outcome and the window, and they decide how they meet it. Route 2 is if you need a fixed nightly window, make the right to subcontract genuine. They can send their own subcontractor to cover that period. The work gets done between 6 and 10 p.m., but it doesn't have to be done by them. So that's how those 2 things work in action, and that's why I wanted to bring in this question myself. Lastly, I just want to say with that question, the trap is that if your agreement says they can subcontract, but in reality you're rejecting them, every sub they bring in, or every person you're saying, oh, no, I don't want them. And the one person still shows up every night, and that's your contractor, that's when the gateway test will fail. Another question I got is, what if my contractor only meets 4 of the 5? Is that close enough? Well, what do we know? I'm going to give you guys, what's your answer? This feels like very much like Blue's Clues. What's your answer, everyone? It is no. All 5 requirements and criteria must be met. The test is binary, yes or no. 4 out of the 5 means that the gateway test fails entirely. So you basically revert back to that real nature analysis. Last couple of questions is, do I have to pay for my contractor's legal advice before they sign? Like I said, the Act says no. Last question is, the 30-day rule is gone. What do I actually say when a new employee asks about the collective? You still have to tell them there is one. You have to give them a copy of the collective and the union's contact details. What you don't have to do anymore is actually physically put them on the collective terms for the first 30 days. So you don't have to sign them up to that. From day 1, you negotiate the individual terms. The information obligation stays the same, but like I mentioned before, the terms obligation is gone. As I wrap this up, I just want to say 3 things from today. 1, all 5 gateway test criteria must be met. Miss 1 and you're back at the old analysis. 2, the test is not retrospective. It applies for relationships and issues arising from 21st February. The old rules still govern claims made before 21st February. And last thing I wanted to mention is paperwork alone won't protect you. Keep that in mind. The relationship has to truly, genuinely reflect the contract. And lastly, before I wrap this all up, if you are tackling anything in the workplace, I run workshops that take your team through exactly these kinds of issues that can crop up, and they are open for booking now. The website is live. Head over to lawlens.co.nz and take a look around. That is it for me, everyone. We are down to the last episode. Thank you so much for tuning in. I really appreciate your time. I hope you have a lovely day, night, evening, whatever it may be, and I will see you very soon. Okay, catch you in the next one, everyone.